take care of a case.
Are we stepping into the world of medical malpractice
I think so,
now?
David.
Okay. Well, if we're going to do that, bear in mind, it's just another form of negligence. An auto accident is an injury caused by somebody's negligence. And negligence, I think we may have talked about a little bit before, is when you don't live up to the standard of care that's expected of a reasonable, ordinary person. What you're now moving into with doctors is living up to the standard of care of a reasonable, ordinary physician with the same training that the doctor that may have caused your injury has had. We don't see oftentimes people come into us who have been injured by something a doctor did that are still treating with that doctor. Usually by the time they come to us, they said, there's a problem, that doctor caused the problem, and I'm not going to treat with that doctor anymore. So you don't get that same length of treatment issue. It's what is the injury, what's the extent of the injury, and is it causally related to something the doctor did that didn't meet the standard of care.
And did we start to broach the subject last time, too, about standard of care versus what his intention was? He meant to do right, but somehow something went awry. Intention matters?
It's the standard of care, as always, with a reasonable, prudent doctor is the standard of care.
So it has nothing to do with whether he intended someone harm.
Are you saying a intentional tort? That's the question?
I guess that.
All right. An intentional tort, as opposed to negligence, would be if somebody intended to hurt you, that is totally different than if someone unintentionally or negligently causes an injury. In the medical malpractice world, what we as lawyers often have to differentiate between is a bad result, where somebody had a procedure or something and it didn't work, and negligence, because they're actually two different things. You could go into a back operation, for example. The doctor can go through the process, and you could be worse than you were before. And that may not necessarily be negligence. That may be you had a bad result. That would have been the same if any other doctor had done the same thing. It's just based on your anatomy and your physiology and what happened in the surgery.
So there's no such thing as satisfaction guaranteed.
Not in the medical field.
However, there is something about informed consent, and I assume that's a very good place for you to elaborate on how that connects with medical malpractice.
Sure.
Well, prior to going into surgery, or I think at any time you go into a physician's office, or if you're facing any type of major procedure, you need to know in advance what may be the result. Like as David was saying earlier, if you go in for back surgery, there's no guarantee that you're going to have the facilities that you did prior to your back being injured. So I think it plays into that.
Right. There are several different ways a doctor can be held liable for something that went wrong. He could have performed that surgery we talked about perfectly well and still have it come out wrong. The doctor, however, may still be liable, as you say, if he didn't give you beforehand a rundown of all the risks you're facing. Because if one of the risks was, say, paralysis, and it's a likely possibility, which is a very serious result, if you weren't told that beforehand and had the option to say, you know what, I don't want this surgery,
then you don't have informed consent.
You don't have informed consent. The doctor could be liable for that, even though he did the procedure properly.
And is it necessary for people to sign off that on a waiver that says, or not a waiver, but sign off that they have been notified of all of the risks and therefore they're not culpable unless there was some negligence?
Yeah, usually in a pre-admission procedure, you go in and they have a whole list of all the possibilities. And, you know, if it's a less than 1% chance that something might happen, they might not have to tell you that unless it's a very serious risk. Anytime death is a risk, I think they should inform you, even if it's less than 1%, people have died from this procedure before. And usually, to protect themselves, they do want it in writing, because how are they going to prove that they gave you all of the risks and options before you gave them your informed consent?
And conversely, if you go in to have your left arm operated on, you've signed your consent forms, if they operate on your right arm, that consent form is
Out the window.
negated. Yeah.
I've had those cases
Yeah.
before. In wrong
So it
site
just doesn't
surgery,
mean because you sign that, that you give up your rights.
wrong site surgery has been a problem, and hospitals have taken steps to correct that. But if you go in to have, as Jackie said, your right arm done and your left arm's operated on, and there are damages to your left arm as a result of that, that clearly doesn't meet the standard of care.
If you're involved in that kind of case, are you likely to have to deal with the suing of a doctor, of the hospital, of the anesthesiologist, of the nurse? How does that play out for attorneys when such an occasion takes place?
Well, the hospital would be liable if something went wrong and they had control over the operating room. The doctors usually are responsible. It could be a nurse. You're in the operating room under general anesthesia. You're not going to be able to point to who it was in the operating room that caused your problem. So as a starting point, you would want to make sure everybody's included. Then as you go through discovery and find out what happened, it may not have been the nurse. The nurse may be free of blame and would get out of the case. But until you know, you have to make sure you include everybody. As we spoke about before, did we talk about statute of limitations? I think we did, but I'll reemphasize it here. In medical malpractice cases, there's a 3-year statute of limitation. That statute of limitation generally runs from the day you knew or should have known that there was malpractice. So there's a little discovery period. If the operation was on one particular day and you didn't know there was a problem for 5 or 6 months later, you'd have 3 years from the date you discovered that there was a problem. Now, once you've discovered there's a problem, if you haven't included all the parties in it, it's difficult unless you can show there's reasonable grounds that you didn't discover it before to bring somebody in after the fact. I've actually worked on some cases, and there's case law in Rhode Island in the Supreme Court that talks about what reasonable steps you have to take about to make sure you've included everybody before that statute of limitations is run.
As a result, it seems that many of the hospitals have put in more securities and checks and balances to make sure that they know who was involved. Now, from your perspective, wouldn't you be more likely to say the doctor or the hospital are most culpable versus the nurse just because they have a higher degree of commitment to it, and certainly the deeper pockets as well, as we might guess?
It depends. I mean, it depends on the facts. Your facts are going to control your case. You have to get
Good point.
opinions from experts. It's going to depend.
It depends
really
what
not
the injury was and how it
Yes.
occurred. If, for example, somebody left an operating instrument inside you and closed you up, who's responsible for that? Is the doctor ultimately responsible? Perhaps. Do the nurses have to take account of all the instruments that were used and what's
In
out?
and out?
Exactly, which I believe they do.
They do.
And if they didn't do that correct, aren't they responsible for that? So, and as employees of the hospital's therefore responsible under the theory we call respondeat superior, which is the employee's negligence is, the employer is responsible for the negligence of their employees.
So when you are taking on such a case, you need to explore with doctors, hospitals, nurses, expert witnesses.
Yeah,
And-
these cases can go on sometimes for years, and they're very expensive to litigate. So there's no such thing in law as a slam dunk. There really isn't.
Right.
The facts control, you need to hire experts. Like David was saying earlier, you need to find somebody that will concur with our opinion or give us an opinion that the procedure was not done within the standard of care of another physician.
And you're,
Most lawyers aren't doctors.
That's
we,
right.
We have a gut feeling as to what seems right and what seems wrong, but we work with many lawyers who do medical malpractice exclusively, and they'll often employ a nurse on staff. And the starting point of the case is they meet with the lawyer, the nurse, and the client come in and they meet together, and they get all the facts. The next step is to get all the medical records. The nurse would then generally review those to say, yeah, I think there's something here. Then it has to be sent out to an expert to review, who's an expert in the same field as the doctor. Because if you have a neurosurgeon who does something, you don't want that case referred to a chiropractor for review. It has to be an expert in the same field.
same
And that's
specialty.
where some of this expense really starts to build up.
about that,